According to Robert O. Sonock in his article in the Judge's Journal, quote, there are over 4,000 missing and murdered Indigenous women in the U.S. and Canada, end quote. Why is this important to you? Well, the murders and disappearances of Indigenous peoples is highly important due to the sheer amount of cases that exist. However, it is important to become familiar with the court case that I will be speaking about today, as it allows for such violence to continue to exist in our current society. As to my credibility, I have done extensive research on this topic through multiple avenues due to my standing as an anthropology major. I believe that I am credible enough to inform you on this topic. The 1978 Supreme Court case Oliphant v. Suquamish Indian Tribe is a highly important case due to its reviews of Native jurisdictional powers and the effects it currently has on present-day Indigenous peoples' rights to sovereignty in judicial matters. In this speech, I will first begin by recounting the story of the court case itself. Second, I will speak about jurisdictional rights pre-Oliphant. And lastly, I will speak about current day issues and Indigenous people who are actually fighting initiatives today. Firstly, Oliphant v. Suquamish Indian Tribe first began as an altercation between non-Native men and tribal police, the first being Mark Oliphant, who would be arrested on August 19th, 1973, and Daniel Blagran, who was arrested on October 12, 1974. To paraphrase Alexandra Harmon in her book Reclaiming the Reservation, Histories of Indian Sovereignty Suppressed and Renewed, Oliphant would attend the festival Chief Seattle Days, which was held on Suquamish land, where he would then assault a police officer and resist arrest. He would then later be released on August 24th. Paraphrasing Harmon again, Police Chief Carl Bigman would be notified of a truck recklessly racing throughout town. Tribal police would attempt to stop the truck, where Belgrand would actually accelerate and hit Chief Bigman's car, injuring him, and then being the only one arrested out of the three passengers, which coincidentally Mark Oliphant was also one. In court, Oliphant would argue that tribal governments had no right to prosecute him. Joseph Matsagani states in his article Slouching Towards Autonomy, Jurisdiction, Native American Autonomy, and Violence Against Women in Indian Country, quote, Oliphant arguing the tribe had no jurisdiction over non-Indians. Both the district court and the Ninth Circuit disagreed, but in a sweeping decision, the Supreme Court reversed both courts and declared that tribes had no criminal jurisdiction over non-Indians, end quote. To paraphrase Matsagani, the outcomes of Oliphant v. Suquamish Indian Tribe would essentially be the beginning of the erosion of Indigenous sovereignty. Now that I've finished speaking about the court case itself, Indigenous nations actually had jurisdictional rights pre-Oliphant. The early federal government even recognized criminal authority. Mara Douglas states in her article that was published in the University of Pennsylvania Law Review, quote, the Cherokee Nation, who was recognized in a treaty with the United States in 1866, recognized the exclusive jurisdiction in all civil and criminal cases arising within their country, in which members of the nation by nativity or adoption shall be the only parties, or where the case of action shall arise in the Cherokee Nation, end quote. Douglas also states in her article, quote, the recognition of tribal criminal jurisdiction as inherent tribal sovereignty was acknowledged in Ex parte Crow Dog, where it was determined that federal courts did not have jurisdiction to prosecute an Indian accused of murdering another Indian in Indian country, end quote. Matsagani states in his article, quote, in the most important decision in federal Indian law, Worcester v. Georgia, Judge Marshall made it clear that there was no role for states to play in tribal relations and that tribes' relationship with the federal government did not strip the tribe of their right of government and end their sovereignty, end quote, which was a highly important decision in our history. Paraphrasing Matsagani again, the indigenous nations, while split up due to an allotment act, would still have power to organize governments and enact authority over themselves because of the Reorganization Act. There was clear initiatives being taken in our past history that would allow indigenous peoples to enact authority over themselves. Due to this court case, however, indigenous peoples are suffering from the jurisdictional issues, and women are now at the forefront of all the violence. Yet there are small steps being taken. Due to the lack of complete jurisdictional power, indigenous nations must base their cases on specific parameters. According to Matsagani, Quote, unlike women of any other race, Native American women victims face a complex jurisdictional web that turns not on the nature of the crime, but on the race of the perpetrator and the physical location of the crime, end quote. Furthermore, Montagani states, quote, under the ICRA, tribes are forced to punish rape and any other crime as no more than a misdemeanor, bolstering the view that tribes neither could nor would exert authority over felonies, end quote. The Violence Against Women Act, or as it's now known as VAWA, has served to be an important asset to regaining sovereignty. However, it still has its gaps. In Summer Blaze's Aubrey's article published in the Arizona Journal Law of Environmental Law and Policy, she states, quote, VAWA state sought to improve criminal justice and community-based responses to domestic violence, dating violence, sexual assault, and stalking in the United States. This reauthorization of VAWA in 2013 recognized that tribes did indeed have inherent powers over prosecuting people who are not a part of their tribe. However, there are gaps, such as Aubrey states in her article, quote, the restrictions of VAWA 2013 provide for massive loopholes in attempting to remedy missing and murdered Indigenous women and girls because the act prevents the prosecution of crime perpetrated by strangers and sexual assault. In conclusion, Oliphant v. Suquamish Indian Tribe is a massively important court case that shaped the lives of millions and restricted jurisdictional power and diminished the indigenous claims to sovereignty. In this speech, I spoke about the story behind the events before the court case and the court case itself. Secondly, I spoke about the history of pre-Oliphant jurisdictional rights. And lastly, I spoke about present-day issues and initiatives being taken to correct such issues. While violence against Indigenous women is not a recent occurrence, it's important to pay attention to court cases like Oliphant v. Suquamish Indian Tribe, as they are part of our history that tells us why things like missing and murdered Indigenous women and girls and Two-Spirits still exist. Thank you.